I was sitting at my desk reviewing a brief when I heard the knock that would change everything. Not a polite knock, but the kind of aggressive pounding that makes you wonder if someone's trying to break down your door. I glanced at my watch. 3:30 on a Tuesday afternoon in suburban Phoenix, Arizona. I set down my pen and walked to the front door of my modest two-story home in the Saguaro Ridge community, wondering what could possibly warrant this kind of urgency. Through the peephole, I spotted a woman in her mid-50s with that distinctive haircut. You know the one. Short, aggressively styled with blonde highlights that screamed middle management at a failing retail chain. She wore a blazer despite the 90-degree heat and clutched a leather portfolio like it contained nuclear launch codes. I opened the door. "Can I help you, Harrison Dalton?" she asked, though her tone suggested she already knew the answer. "That's me. I'm Patricia Hendricks, president of the Saguaro Ridge Homeowners Association." She thrust a business card at me. "We need to conduct an immediate inspection of your property." I took the card, noting the pretentious script font. "An inspection? For what purpose?" "We've received complaints about unauthorized modifications to your home. According to Section 7.3 of the HOA covenants, we have the right to inspect any property within the community boundaries with reasonable notice." "And you consider this reasonable notice?" I asked, keeping my tone neutral. "We sent you a letter 3 days ago," she said, her voice dripping with condescension. "I haven't received any letter, but even if I had, that doesn't give you the right to enter my home." Patricia's expression hardened. "Mr. Dalton, you signed the HOA agreement when you purchased this property. That gives us certain rights." I felt something click in my brain, the same feeling I get in a courtroom when opposing counsel makes a critical error. See, Patricia had no idea who she was dealing with. "I'm a constitutional lawyer specializing in property rights and civil liberties. I've argued cases before the Ninth Circuit. And this woman thought she could intimidate me with a cheap leather portfolio and a bad attitude." "Miss Hendricks," I said calmly, "I'm familiar with HOA agreements. But they don't supersede the Fourth Amendment. You have no right to enter my home without my consent or a warrant." Her face flushed. "This is HOA property, Mr. Dalton. You don't actually own this land. You own a conditional right to occupy it subject to our rules." That wasn't how property law worked, but I could see she believed it. "What exactly do you think I've modified?" "That's what we need to determine. We have reports of possible structural changes, unauthorized paint colors, and violations of the landscaping code." I glanced at my house. The exterior was the same beige stucco it had been when I bought it 2 years ago. My front yard featured desert landscaping with native plants, which actually exceeded the HOA's environmental guidelines. "My property is in full compliance. We'll be the judge of that," Patricia said. "Now, are you going to let us in, or do we need to take further action?" "Us?" I asked. She gestured behind her, and I noticed 2 other people standing on my driveway. A balding man in his 60s wearing khakis and a polo shirt, and a younger woman with a clipboard who looked deeply uncomfortable with the entire situation. "This is Gerald Thompson, our architectural compliance officer, and Sarah Chen, our secretary," Patricia announced. "We're all here to conduct the inspection." I pulled out my phone. "Before this goes any further, I want to make something clear. I'm recording this conversation, which is my right under Arizona's one-party consent law. You do not have permission to enter my home. If you attempt to do so, you'll be trespassing." Patricia's eyes narrowed. "You can't record us without permission." "Actually, I can. Arizona Revised Statute Section 13-3005 specifically allows for one-party consent in recording conversations. Since I'm a party to this conversation, I'm well within my legal rights." Gerald stepped forward. "Sir, we don't want any trouble. We just need to verify compliance with community standards. Then make an appointment like normal human beings," I said. "You can't show up at someone's house demanding entry. That's not how this works." Patricia pulled out her phone. "I'm calling our HOA attorney." "Please do," I replied. "I'd love to hear what they have to say about this approach." She stepped away, speaking in hushed but angry tones. Sarah, the secretary, caught my eye and mouthed sorry. I nodded at her. She clearly didn't want to be here. While Patricia was on the phone, Gerald tried a different approach. "Mr. Dalton, I understand you're concerned about your rights. But you have to understand, we're just trying to maintain property values for everyone in the community." "By violating constitutional rights?" I asked. "That's not a trade I'm willing to make." "It's not a violation if you agreed to it in the contract," he argued. "Contracts can't waive constitutional rights," I explained. "If I signed a contract saying you could search my home anytime you wanted, it would be unenforceable. The Fourth Amendment protects against unreasonable searches, and a warrantless entry into someone's home is the definition of unreasonable," Patricia returned, looking triumphant. "Our attorney says you're required to allow reasonable inspections under the HOA agreement. If you refuse, we can fine you up to $500 per day and place a lien on your property." I almost laughed. "Your attorney is wrong, or you misunderstood what they said. Yes, the HOA agreement allows for exterior inspections of the property. But that doesn't extend to the interior of my home without consent or exigent circumstances." "The agreement says property, not exterior," Patricia countered. "And property law has well-established boundaries between curtilage and interior space. You can look at my yard. You can examine my roof from the street, but you cannot enter my home." "So you're refusing?" she asked, her voice rising. "I'm asserting my constitutional rights," I corrected. "There's a difference." Patricia opened her portfolio and pulled out a form. "Then I'm issuing you a violation notice for failure to cooperate with a legitimate HOA inspection. You have 14 days to allow the inspection or face escalating fines." She thrust the paper at me. I took it, still recording everything on my phone. "Additionally," she continued, "we're issuing violation notices for the following: unauthorized exterior modifications, non-compliant landscaping, and violation of the community aesthetic standards." "Specifically, what modifications?" I asked. "That's what we need to inspect to determine," Patricia said with a satisfied smile. "So you're issuing violation notices for unspecified violations that you need to inspect to identify. Do you understand how circular that logic is? The violations exist, Mr. Dalton. Your refusal to cooperate only confirms our suspicions." I looked at Gerald and Sarah. "Are you both comfortable with this approach?" Sarah looked at her shoes. Gerald shifted uncomfortably. "We're just following procedure," he mumbled. "Procedure that violates federal constitutional law," I said. "You might want to consider the personal liability implications of that." That got Gerald's attention. "Personal liability? Under 42 U.S.C. Section 1983, individuals who violate someone's civil rights under color of law can be held personally liable for damages. Now, typically that applies to government actors, but HOAs occupy a strange quasi-governmental space, and some courts have extended that liability." Patricia waved her hand dismissively. "Nice try, counselor, but HOAs are private organizations. We're not subject to constitutional limitations." "Actually, that's a complex area of law," I said. Shelley v. Creamer established that state enforcement of private contracts can constitute state action. And the Supreme Court in Marsh v. Alabama held that private entities performing public functions can be subject to constitutional constraints. "This isn't a company town," Patricia snapped. "No, but you're exercising quasi-governmental powers over a residential community. You collect mandatory fees, enforce regulations, and claim authority to fine and place liens. Several circuit courts have found that sufficient to trigger constitutional protections." "You're just making this up to avoid compliance," Patricia said. I smiled. "I'm a constitutional lawyer, Miss Hendricks. This is literally what I do for a living. I've published articles on HOA overreach and property rights. I've testified before state legislatures on HOA reform, and I've successfully sued 3 HOAs for civil rights violations." For the first time, I saw doubt flicker across Patricia's face, but she recovered quickly. "Then you should know that property owners have an obligation to maintain community standards. I should also know, and do know, that those obligations can't violate fundamental rights. Now, if you'd like to schedule an exterior inspection during reasonable hours with proper notice, I'm happy to accommodate that. But you're not entering my home without consent or a warrant. Those are your only 2 options." Patricia's face turned an impressive shade of red. "This isn't over, Mr. Dalton. The board will be discussing this matter at our next meeting. You're welcome to attend, though I doubt it will change anything." "When's the meeting?" I asked. "Thursday night, 7 p.m. at the community center." "I'll be there," I said, "with my attorney hat on." "You're going to represent yourself?" Patricia asked, her tone mocking. "You know what they say about lawyers who represent themselves. They usually win against people who don't know what they're talking about," I replied pleasantly. Patricia spun on her heel and marched back to her white Lexus SUV. Gerald and Sarah followed, though Sarah glanced back with an apologetic expression. I stood in my doorway, still recording as they drove away. Only then did I stop the recording and back it up to my cloud storage. In my line of work, I'd learned that documentation was everything. I went back inside and pulled up the HOA covenants on my computer. I'd read them before purchasing the house, but I wanted to review the exact language about inspections. Sure enough, Section 7.3 read, "The association reserves the right to inspect properties within the community to ensure compliance with these covenants, with reasonable notice to the property owner." Nothing about entering homes, nothing about warrantless searches. The language clearly contemplated exterior inspections only, which made sense. HOAs could reasonably regulate external appearance to maintain community aesthetics, but they had no legitimate interest in the interior of someone's home. I drafted a letter to the HOA board, carefully laying out the legal issues with their attempted search. I cited relevant case law, explained the Fourth Amendment implications, and offered to cooperate with a reasonable exterior inspection. I also requested copies of any complaints that had been filed about my property, as I was entitled to know the specific allegations against me. Then I called a colleague of mine, Marcus Webb, who specialized in HOA law. He picked up on the second ring. "Harrison, what's up?" "I just had the HOA president try to force her way into my house," I said. Marcus laughed. "You're kidding." "Dead serious. Showed up with 2 other board members, demanded entry to conduct an inspection, and threatened fines when I refused. Please tell me you recorded it." "Every second." "Beautiful. What's the HOA's name?" "Saguaro Ridge Community Association." I heard typing on the other end. "Oh man. Harrison, you hit the jackpot. This HOA has been sued twice in the last 5 years. Once for selective enforcement, once for improper foreclosure proceedings. They lost both cases." "Who was representing them?" "Some local firm. Brennan and Associates. They're not great, honestly. They mostly do real estate closings and basic contract work. I don't think they have anyone with significant civil rights experience. So the HOA keeps getting bad legal advice and making the same mistakes, I said. Exactly. And now they've messed with someone who actually knows what they're doing. What are you thinking? Right now, just protecting my rights and documenting everything. But if they follow through on these bogus fines or try to place a lien, I'll file suit. Want me to co-counsel? Marcus asked. This could be a good case to establish some precedent on HOA Fourth Amendment issues. Let me see how Thursday's board meeting goes. If they double down on this, we might have a legitimate civil rights case. Keep me posted. And Harrison, enjoy this. It's not often we get to defend our own homes from petty tyrants. I spent the next day preparing for the board meeting like I'd prepare for oral arguments. I pulled every relevant case, drafted a presentation outline, and reviewed Arizona's HOA statutes. I also filed a public records request with the HOA for all complaints filed about my property, all board meeting minutes from the past year, and copies of the HOA's insurance policies. If this turned into litigation, I wanted to know their coverage limits. Wednesday afternoon, I received a certified letter from the HOA. Inside were 3 separate violation notices, each threatening a $500 daily fine. Violation 1. Unauthorized structural modifications to primary residence. Violation 2. Non-compliant exterior color scheme. Violation 3. Landscaping violations including prohibited plant species. All 3 were complete fiction. I'd made 0 structural modifications. My house was the exact same beige as 70% of the neighborhood, and my landscaping consisted entirely of native desert plants that were explicitly encouraged in the HOA's environmental guidelines. I photographed everything and added it to my growing evidence file. Thursday evening, I arrived at the community center at 6:45. The building was a modest single-story structure with a meeting room, small kitchen, and gym. About 20 residents were already seated in the meeting room, chatting quietly. I took a seat in the front row and set my briefcase beside me. At precisely 7 p.m., Patricia walked to the front table where Gerald and 2 other board members were seated. I recognized one as Linda Morrison, the treasurer. The other was a man I hadn't seen before, presumably the vice president. This meeting of the Saguaro Ridge Community Association Board is now in session, Patricia announced. I'm Patricia Hendricks, president. With me are Vice President Donald Fletcher, Treasurer Linda Morrison, and Architectural Compliance Officer Gerald Thompson. Secretary Sarah Chen is taking minutes. Sarah sat at a small table to the side, her laptop open. She caught my eye and quickly looked away. Patricia went through standard business. Approval of last month's minutes, financial report, updates on landscaping contracts. I waited patiently. Finally, she reached the agenda item I was waiting for. New business. We have a significant compliance issue with one of our residents. Mr. Harrison Dalton has refused to allow a legitimate inspection of his property and has been issued multiple violation notices. I raised my hand. Point of order. Patricia's expression soured. Mr. Dalton, I should have known you'd be here. You invited me, I said pleasantly. May I address the board? This isn't a hearing, Patricia said. We're discussing compliance actions. Actions that directly affect me, I countered. Under basic principles of due process, I have a right to be heard before you impose fines or penalties. Donald, the vice president, leaned toward Patricia and whispered something. She looked annoyed but nodded. Fine. You have 5 minutes. I stood and walked to the front of the room, placing my laptop on the table. Thank you. I want to start by addressing the allegation that I refused a legitimate inspection. That's not accurate. What I refused was an unconstitutional warrantless search of my home. The HOA agreement allows inspections, Patricia interrupted. May I finish? I asked. You gave me 5 minutes. She gestured impatiently. The HOA covenants allow for property inspections with reasonable notice. I've reviewed the language carefully. It clearly refers to exterior inspections to ensure compliance with community standards. At no point does it authorize entry into a resident's home. Such entry would require consent or a warrant, neither of which you had. I pulled up a slide on my laptop showing the relevant constitutional text. The Fourth Amendment to the United States Constitution protects against unreasonable searches and seizures. It's well-established law that warrantless entry into someone's home is presumptively unconstitutional. There are exceptions for emergencies, hot pursuit, and other exigent circumstances, but we want to check for HOA violations isn't one of them. Linda raised her hand. But HOAs are private organizations. The Constitution only limits government action. That's a common misconception, I said. While it's true that the Constitution primarily constrains government actors, courts have recognized that private entities can be subject to constitutional limitations when they exercise governmental functions. HOAs collect mandatory fees, enforce regulations, and have the power to fine residents and place liens on property. Several courts have held that this quasi-governmental authority triggers constitutional protections. I advance to the next slide, showing case citations. In Committee for a Better Twin Rivers v. Twin Rivers Homeowners Association, the New Jersey Supreme Court recognized that HOAs exercise certain governmental functions. While they ultimately ruled narrowly in that case, they acknowledged the constitutional concerns. And in Laguna Publishing v. Golden Rain Foundation, the California Court of Appeal held that HOA common areas could be considered a public forum for First Amendment purposes. That's California, Patricia said dismissively. It's persuasive authority, I replied. But even if we set aside the state action question, there's a more fundamental issue. The HOA agreement is a contract, and contracts cannot waive constitutional rights. If I signed a contract saying you could search my home anytime you wanted, that provision would be unenforceable as against public policy. You cannot contract away fundamental constitutional protections. Donald spoke up. Mr. Dalton, I hear what you're saying about the interior of your home. But what about the exterior? We have received complaints. What complaints specifically? I asked. I submitted a public records request for those complaints and haven't received a response. Patricia shuffled papers. We're not required to disclose complaint details. Actually, under Arizona law, HOAs are required to maintain certain records and make them available to homeowners upon request. That includes complaints filed about their property. We'll get to your request, Patricia said dismissively. It's been 3 days. Arizona Revised Statutes Section 33-1805 requires HOAs to respond to records requests within 10 business days, but common practice is much faster for simple requests. The fact that you're stonewalling suggests these complaints don't exist. The room was silent. Several residents were taking notes. I continued. The violation notices I received are vague and conclusory. I'm accused of unauthorized structural modifications, but no one has identified what those modifications are. My exterior color is supposedly non-compliant, but it's the same color as most homes in this neighborhood and hasn't changed since I bought the property. And I'm accused of landscaping violations, despite using exclusively native plants that are encouraged in the HOA guidelines. I turned to face the other residents. What's happening here is called selective enforcement. The board has decided they don't like me or don't like that I know my rights, so they're making up violations to harass me. That's illegal. It's a breach of the implied covenant of good faith and fair dealing, and it opens the HOA up to significant liability. Patricia stood abruptly. This is absurd. We're trying to maintain community standards and you're throwing around legal threats. I'm explaining the law, I corrected. Something your attorney should have done before you showed up at my door demanding entry. Speaking of which, I'd like to make a formal request that the board consult with qualified legal counsel about this matter. Not real estate attorneys who dabble in HOA work, but someone who actually understands constitutional law and civil rights litigation. Our attorney is perfectly qualified, Patricia snapped. Then have them review the recording of your visit to my home. I'll happily provide a copy. Let them tell you whether demanding warrantless entry to a homeowner's residence is consistent with current law. I looked at each board member. I'm not trying to be difficult. I follow the rules. My property is well maintained and in full compliance with the covenants. But I won't allow violations of my constitutional rights, and I won't accept harassment disguised as enforcement. I'm asking the board to withdraw these baseless violation notices and work with me cooperatively if there are legitimate concerns about my property's exterior appearance. Donald whispered to Patricia again. She looked furious but sat down. We'll take your comments under advisement, she said stiffly. Is there anything else? Just one thing. If the board proceeds with these fines or attempts to place a lien on my property, I will file suit in federal court under 42 U.S.C. Section 1983 for deprivation of civil rights under color of law. I'll also file state claims for breach of contract, breach of the implied covenant of good faith and fair dealing, and intentional infliction of emotional distress. Given this HOA's history of losing lawsuits, I'd think carefully before going down that road. I returned to my seat. The room was buzzing with conversation. Patricia tried to restore order. If there's no other business, this meeting is adjourned. Wait, someone called out. I turned to see a woman in her 40s standing. I'm Jennifer Martinez. I live on Desert Willow Drive. I want to hear more about what Mr. Dalton said regarding selective enforcement. This isn't the time, Patricia said. Actually, meetings are supposed to be open for homeowner comments, Jennifer said. That's in our bylaws. Patricia looked like she'd swallowed something bitter. Fine. You have 2 minutes. Jennifer stood. I've lived here for 8 years. In that time, I've watched this board play favorites constantly. My neighbor painted his house a different shade of tan without approval, and the board gave him a pass because he's friends with Patricia. But when I wanted to plant some rose bushes, I got violation notices. This needs to stop. Another man stood. I'm Robert Chen. I'm Sarah's husband. Sarah has told me about some of the things this board does, and honestly, I'm concerned about the legal exposure we all face as homeowners. If the HOA gets sued and loses, that comes out of our reserve funds and could result in special assessments. Everyone's property is affected, I added. If the HOA makes poor legal decisions and faces judgments, all homeowners pay the price through increased fees or assessments. More residents started speaking up, sharing their own experiences with selective enforcement and overreach. Patricia tried to maintain control, but the meeting devolved into an open forum on board accountability. Finally, Patricia stood and walked out, followed by Gerald and Linda. Donald remained, looking uncomfortable. I apologize for how this has been handled, he said quietly. Some of us on the board have concerns about Patricia's approach, but she's very forceful and difficult to disagree with. Then vote her out, Jennifer said. When are elections? Next month, actually, Sarah spoke up. We elect new officers in March. I nominate Mr. Dalton for president, Jennifer said. I held up my hands. I appreciate that, but I have no interest in running the HOA. I just want to be left alone to live in my house peacefully. But you clearly know the law better than the current board, Robert said. Knowing the law and wanting to spend my evenings dealing with HOA politics are two different things, I replied. What I will do is help educate homeowners about their rights and support board members who want to follow the law. Donald nodded. That would be helpful. I'm not running for re-election. I'm tired of fighting losing battles. But maybe some of the people in this room would make better board members. The informal meeting continued for another hour. Several residents expressed interest in running for the board. Others shared horror stories about Patricia's enforcement decisions. It became clear that I wasn't the only one who'd been targeted. I drove home feeling cautiously optimistic. Maybe the community would vote in a reasonable board, and this would resolve itself. But I'd been a lawyer long enough to know that people like Patricia didn't give up power easily. Friday morning, I woke to find an email from the HOA attorney, Daniel Brennan. It was professionally worded but essentially backed Patricia's position. He claimed the HOA had broad inspection rights and that my refusal to cooperate was a violation of the covenants. He made no mention of constitutional concerns. I replied with a detailed letter explaining why he was wrong, attaching relevant case law and statutory citations. I also noted that I'd be filing a bar complaint if he continued to provide advice that encouraged constitutional violations. That afternoon, I received a call from an unknown number. Mr. Dalton. This is Donald Fletcher. We spoke at the board meeting. Yes, I remember. I'm calling because I think you should know what's happening. Patricia held an emergency board meeting this morning without proper notice. Just her, Gerald, and Linda. They voted to impose the fines on your property effective immediately and authorized filing a lien. My jaw clenched. They can't hold a board meeting without proper notice. I know. That's why I'm calling. I wasn't invited and neither was Sarah. According to our bylaws, we need at least 3 board members for a quorum, and all members must be notified of meetings except in genuine emergencies. This wasn't an emergency. Exactly. I think Patricia knows the elections are coming, and she's trying to force this through before she potentially loses power. I wanted you to know so you can take appropriate action. Thank you, Donald. I appreciate you calling. For what it's worth, I think you're completely right about the legal issues. I should have spoken up sooner. After we hung up, I sat at my desk and made a decision. I'd tried to resolve this reasonably. I'd offered compromises. I'd explained the law. Patricia had rejected every opportunity to back down. Now she was violating the HOA's own bylaws to push through illegal fines. It was time to file suit. I spent the weekend drafting a comprehensive federal complaint. I named the HOA as the primary defendant and included Patricia, Gerald, and Linda in their individual capacities. I alleged violations of the Fourth Amendment, deprivation of civil rights under color of law, breach of contract, breach of the implied covenant of good faith and fair dealing, and violation of Arizona's HOA statutes. The damages I sought included declaratory relief, that the fines were unlawful, injunctive relief preventing enforcement of the lien, compensatory damages for the time I'd spent dealing with this harassment, and punitive damages to deter future misconduct. I also sought attorney's fees under federal civil rights statutes. Monday morning, I filed the complaint in the United States District Court for the District of Arizona. I also filed an emergency motion for a temporary restraining order preventing the HOA from recording a lien until the court could hold a hearing. By noon, the HOA had been served. By 2 p.m., my phone was ringing off the hook. I ignored calls from Patricia's number but answered when I saw Daniel Brennan's name. "Mr. Dalton, I received the complaint. I think we should discuss settlement." "Now you want to settle?" I asked. "After weeks of harassment and baseless threats." My clients were acting on their good faith interpretation of the HOA covenants. "Your clients held an illegal board meeting to impose unlawful fines for non-existent violations. That's not good faith. That's malice." "I understand you're upset, but litigation is expensive and time-consuming for everyone." "I'm a lawyer, Mr. Brennan. Litigation is my day job, and I'm representing myself, so I have no legal fees. The HOA, on the other hand, will be paying your hourly rate. How much do you charge?" $300 an hour. $400. This case could easily run up 6 figures in fees before we even get to trial. Silence on the other end. "Here's what I'll accept," I said. "The HOA withdraws all violation notices and fines. They issue a written apology acknowledging that they overstepped. They agree not to attempt any interior inspections of my home without consent or a warrant, and they pay $50,000 in damages and attorney's fees." $50,000. That's outrageous. It's less than you'll spend in legal fees if this goes to trial. And it's a fraction of what a jury might award if they hear about the HOA's history of losing lawsuits and Patricia's pattern of harassment. "I've done some research, Mr. Brennan. Your clients have already paid out over $200,000 in settlements and judgments in the past 5 years. Maybe it's time to stop making the same mistakes. I'll discuss it with the board. You have until Friday. After that, I'm proceeding with discovery, and I'll be deposing every board member under oath. I'll also be subpoenaing all HOA records, emails, and text messages. If there's any evidence of coordination to target me specifically, that's going to make the damages much worse." I hung up feeling satisfied. Sometimes you have to fight fire with fire. The court scheduled a hearing on my temporary restraining order for Wednesday morning. I spent Tuesday preparing my arguments and organizing my evidence. I had the recording of Patricia's visit, the bogus violation notices, documentation that my property was in full compliance, and Donald's testimony about the illegal board meeting. Wednesday morning, I arrived at the courthouse early. The federal courthouse in Phoenix was an impressive building, and I'd argued several cases here over the years. Today felt different, though. Personal. Daniel Brennan showed up with Patricia, Gerald, and Linda in tow. Patricia looked furious. Gerald looked nervous. Linda kept checking her phone. We were assigned to Judge Margaret Rivera, a Clinton appointee with a strong record on civil liberties. I couldn't have asked for a better draw. The courtroom deputy called the case. Dalton v. Saguaro Ridge Community Association et al. Emergency motion for temporary restraining order. Judge Rivera looked down from the bench. "Mr. Dalton, you're representing yourself." "Yes, Your Honor. I'm a member of the bar in this district." "I recognize you, Mr. Dalton. I believe you argued a First Amendment case before me last year." "That's correct, Your Honor. Martinez v. City of Scottsdale. As I recall, you won that case. Let's hope your luck holds. Please proceed with your motion." I stood and laid out my case clearly and concisely. I explained Patricia's demand to enter my home, my refusal based on Fourth Amendment grounds, the baseless violation notices, and the illegal board meeting to impose fines. I played the recording of Patricia's visit, which drew raised eyebrows from the judge. "Miss Hendricks, you actually told Mr. Dalton that he didn't own his property?" Judge Rivera asked. Patricia stood awkwardly. That's not exactly what I meant, Your Honor. I was explaining that HOA property is subject to community regulations. It sounded to me like you claimed a right to enter his home without permission. Is that your position? Daniel Brennan jumped in. Your Honor, if I may, the HOA covenants do provide for property inspections. Counselor, I've reviewed the covenants. They mention exterior inspections. Where do they authorize entry into a resident's home? The language says property, Your Honor. That could be interpreted to include interiors. Could be interpreted by whom? No reasonable person would read a standard HOA covenant as authorizing warrantless home searches. The Fourth Amendment protects the home as the most sacred of private spaces. You're seriously arguing that someone waives that protection by buying a house in an HOA community. HOAs serve an important function in maintaining property values, Brennan argued weakly. Property values don't trump constitutional rights, Judge Rivera said sharply. Mr. Dalton, what relief are you seeking? A temporary restraining order preventing the HOA from recording a lien on my property or attempting to collect the fines they've imposed. I'm also asking the court to order the HOA to withdraw the violation notices pending resolution of this case. Mr. Brennan, does your client have any evidence that Mr. Dalton's property is actually in violation of HOA standards? We need to conduct an inspection to determine that, Your Honor. An exterior inspection, ideally a full inspection, of the interior of his home, if necessary. Judge Rivera's expression made clear what she thought of that argument. Here's what's going to happen. I'm granting the temporary restraining order. The HOA is prohibited from recording a lien, collecting fines, or taking any enforcement action against Mr. Dalton's property pending further proceedings. Additionally, I'm ordering that if the HOA believes there are exterior violations, they may conduct a visual inspection from public areas only. They may not enter Mr. Dalton's curtilage without his consent. Your Honor, that's too restrictive, Brennan protested. Would you prefer I make it a preliminary injunction? I can schedule a full hearing if you'd like. But I warn you, based on what I've heard today, your clients are on thin ice. The recording of Miss Hendricks' visit is troubling. The violations notices appear to be pretextual. And an illegal board meeting to impose fines. That borders on fraud. Patricia whispered urgently to Brennan. We'd like to discuss settlement, Your Honor, Brennan said. Excellent. Mr. Dalton, are you amenable to settlement discussions? I've made my position clear, Your Honor. If the defendants are willing to meet my terms, we can resolve this today. Judge Rivera looked at Brennan. Take your clients outside and have a conversation. You have 30 minutes. If we don't have a settlement by then, I'm setting this for a full preliminary injunction hearing and we'll proceed with discovery. We filed out to the hallway. Patricia immediately launched into an angry tirade. This is absurd. He's making us look like criminals. You are acting like criminals, I said calmly. You attempted an unlawful search, imposed fines for non-existent violations, and held an illegal board meeting. That's not even getting into the selective enforcement issues. We were protecting the community. You were abusing your power. There's a difference. Brennan pulled Patricia aside. I could hear him explaining in increasingly urgent terms how badly this could go for them. Linda and Gerald stood quietly, looking defeated. Finally, Brennan returned. We can agree to withdraw the violation notices and fines. But $50,000 is too much. It's non-negotiable, I said. You're going to spend that much in legal fees anyway. This is your chance to cut your losses. We can offer $25,000. $50,000. Or we go back in there and I ask the judge to schedule depositions for next week. I'll depose Patricia first and ask her under oath about every enforcement decision she's made in the past 3 years. Then, I'll subpoena your emails and text messages. How confident are you that there's no smoking gun evidence of selective enforcement or personal animus? Brennan looked at Patricia, whose face had gone pale. We need to discuss this with the full board, Brennan said. You've got 15 minutes before the judge expects an answer, I replied. They huddled together, speaking in hushed but heated tones. Patricia was clearly against settling, but Linda and Gerald looked ready to cave. Finally, Brennan broke away. We'll agree to your terms. $50,000, withdrawal of all violations and fines, written apology, and no interior inspections without consent or warrant. I also want Patricia Hendricks removed as HOA president, I added. That's not within our power, Brennan said. The homeowners elect board members. Fine. But I want it in writing that she'll recuse herself from any future decisions regarding my property. Brennan nodded. I can agree to that. We drafted a settlement agreement on the spot, using the courthouse business center to print copies. Patricia signed with a pen that nearly tore through the paper. Back in the courtroom, we presented the settlement to Judge Rivera. Mr. Dalton, are you satisfied with these terms? She asked. Yes, Your Honor. Miss Hendricks, do you understand that you're agreeing not only to cease enforcement actions but also to pay damages to Mr. Dalton? Patricia's jaw was clenched. Yes, Your Honor. And you understand that if you violate this agreement, you'll be back before me on a contempt charge? Yes, Your Honor. Good. I'm entering this settlement agreement as a consent order, case dismissed. And Miss Hendricks, I suggest you familiarize yourself with the Constitution before exercising authority over other people's lives. Patricia stormed out without another word. Gerald and Linda followed. Brennan gathered his files and left quickly. I stood in the courtroom for a moment, savoring the victory. Then I packed up my briefcase and headed home. The settlement check arrived 2 weeks later. $50,000 felt good, but the real victory was knowing I'd stood up for my rights and won. The written apology was framed and hung in my office as a reminder. The HOA elections happened in March, as scheduled. Patricia ran for re-election, but she lost badly. Jennifer Martinez became the new president, with Robert Chen as vice president. Donald stepped down as planned. Sarah remained as secretary, but reported that the new board was far more reasonable and focused on actual community issues rather than petty power trips. My first interaction with the new board came in April when Jennifer knocked on my door. This time it was a polite knock. Mr. Dalton, I'm sorry to bother you. I'm Jennifer, the new HOA president. I remember you from the meeting, I said. Please call me Harrison. Harrison, I wanted to personally apologize for how you were treated. The old board's behavior was unacceptable. I've reviewed your property file, and there were never any legitimate violations. Patricia literally made them up because you challenged her authority. I appreciate you saying that. I also wanted to let you know we've retained new legal counsel, someone who actually understands civil rights law. We're reviewing all of Patricia's enforcement decisions from the past 3 years to identify anyone else who might have been targeted unfairly. That's excellent, I said. Good governance matters. We're also revising the HOA bylaws to add better checks on board authority and clearer procedures for homeowner appeals. I was hoping you might be willing to review the proposed changes and provide feedback. I'd be happy to, I said, on one condition. I'm doing it as a neighbor, not as an attorney. I don't want to become the HOA's unpaid legal counsel. Jennifer laughed. Fair enough. We'll pay our attorney for legal advice, but your perspective as someone who lives here and knows the law would be valuable. Over the next few months, I worked with the new board to implement reforms. We created an appeals process for violation notices. We established clearer standards for enforcement decisions. We added language to the bylaws explicitly stating that the HOA could not enter homeowner residences without consent. And we implemented term limits for board positions to prevent the kind of entrenched power that had enabled Patricia's abuses. Patricia, for her part, disappeared from HOA activities entirely. I heard through the neighborhood grapevine that she was considering selling her house and moving. I couldn't say I was sorry to see her go. One evening in June, I was grilling in my backyard when my phone rang. It was Marcus Webb, my attorney friend. "Harrison, I just heard about your HOA case. Why didn't you tell me it's settled?" "It happened fast," I said. "They caved pretty quickly once the judge made clear how weak their position was." "You should write this up," Marcus said. "Seriously. It's a great example of HOA overreach and how to push back. I bet the Arizona Bar Journal would publish it." "Maybe I will," I said, "though I'd rather just enjoy my backyard and my victory in peace." "That's fair. But you know what this means, right?" "What's that?" "You're now the guy every homeowner in Arizona is going to call when they have HOA problems. You're going to get so many referrals." He wasn't wrong. Word spread quickly through legal circles about the case. I started getting calls from homeowners across the state dealing with similar issues. Some cases I took on. Others I referred to colleagues. But all of them reinforced the same lesson. HOAs have legitimate functions, but they're not above the law. The broader impact became clear when the Arizona legislature took up HOA reform. One state representative, who'd heard about my case, introduced a bill to clarify the limits of HOA inspection authority and strengthen homeowner protections. The bill explicitly prohibited HOAs from entering residences without consent or a warrant, with violations subject to civil penalties. I testified at the committee hearing, describing my experience and explaining the constitutional issues at stake. Other homeowners testified about their own nightmares with overreaching HOAs. The bill passed unanimously and was signed into law by the governor. The law made headlines. "Arizona cracks down on HOA overreach," one newspaper declared. "New law protects homeowner rights," another announced. Several articles mentioned my case as the catalyst for the reforms. Patricia must have seen the news coverage. One day in August, I found a letter in my mailbox. It was from her, though she'd moved to a condo in Tucson. The letter was short. "Mr. Dalton, I've had time to reflect on what happened. I still believe HOAs serve an important purpose, but I recognize now that I went too far. I let my desire for control override common sense and legal boundaries. I'm sorry for the stress I caused you. Patricia." It wasn't a perfect apology, but it was something. I filed it away with the other documents from the case. Life in Saguaro Ridge improved dramatically under the new board. Enforcement became reasonable and consistent. Homeowners felt heard. The community even started having events again. Neighborhood barbecues and holiday parties that had fallen by the wayside during Patricia's reign. I attended some of these events, and it was interesting to see how people reacted to me. Some treated me like a hero. Others were cautious, worried I'd sue at the drop of a hat. I tried to be just a regular neighbor, someone who happened to know constitutional law and wasn't afraid to use it when necessary. The truth was, I never wanted to be the guy fighting his HOA. I just wanted to live peacefully in my home. But when Patricia showed up demanding entry, she'd crossed a line that couldn't be uncrossed. The Fourth Amendment isn't just words on paper. It's a fundamental protection that distinguishes free societies from authoritarian ones. The idea that your home is your castle, that the government or quasi-governmental entities can't just walk in whenever they feel like it, is essential to liberty. Patricia had forgotten that. Or maybe she'd never really understood it. She'd gotten so caught up in her own authority, in the power of being HOA president, that she'd lost sight of the fact that she was serving the community, not ruling it. The case taught me something important about the law. It's not just abstract principles argued in courtrooms. It's personal. It's about protecting your home and your family from overreach. It's about standing up when someone with a little bit of power tries to abuse it. And it's about having the knowledge and courage to say no when someone claims authority they don't have. I thought about that as I sat on my porch one evening in September, watching the sun set over the Arizona desert. My home was truly mine now, in a way it hadn't been when Patricia was threatening fines and liens. The settlement money was nice. The apology was satisfying. But the real victory was knowing I could live here without looking over my shoulder, without worrying that the HOA would show up demanding entry. The doorbell rang, interrupting my thoughts. I walked inside to find Jennifer standing there with a bottle of wine. "Peace offering," she said. "Though I think we're past needing those." "Come on in," I said. We sat in my living room, the same living room Patricia had demanded to search. Jennifer looked around. "You know what's funny?" she said. "Your house is probably the most well-maintained property in the neighborhood." The whole thing was always ridiculous. Patricia needed an enemy, I said. I was convenient. "More than that," Jennifer replied. "You challenged her. Most people backed down when she got aggressive. You didn't. That threatened her entire approach to leadership." "Leadership," I repeated. That's a generous word for what she was doing. True. Dictatorship might be more accurate. We talked for a while about the neighborhood, the new board initiatives, plans for community improvements. It was pleasant, normal, the kind of conversation neighbors should have. As Jennifer was leaving, she paused at the door. "Harrison, can I ask you something? Why didn't you just let them do the inspection? Even though they had no right, it would have been easier. You could have shown them there was nothing wrong and moved on." I thought about how to answer that. Because it wouldn't have stopped there. Patricia would have found something else. And even if she didn't, the principle matters. If we let people violate our rights because it's easier than fighting, we lose those rights. The Fourth Amendment only means something if we're willing to defend it. Jennifer nodded. "That makes sense. And for what it's worth, I'm glad you fought. It made the whole community better." After she left, I returned to my porch. The stars were coming out now, brilliant in the desert sky. I thought about everything that had happened since that day Patricia knocked on my door. The confrontation, the bogus violations, the lawsuit, the settlement, the reforms. It had been exhausting and stressful, but also clarifying. I'd spent my career as a constitutional lawyer arguing abstract principles. Now, I'd lived those principles. I'd defended my own rights in my own home. And I'd won not just for myself, but for every homeowner who'd been bullied by an overreaching HOA. The experience made me better at my job. When clients came to me now with civil rights cases, I understood on a visceral level what they were going through. The anger, the frustration, the determination to fight back. It wasn't just about legal theories anymore. It was personal. I also developed a specialty in HOA litigation. Marcus had been right about the referrals. I became the go-to lawyer in Arizona for homeowners dealing with HOA overreach. Some cases settled quickly once the HOA realized they were dealing with someone who knew the law. Others went to trial. I won most of them. Each case reinforced the same lesson Patricia had taught me. HOAs serve a legitimate purpose, but they need oversight and accountability. Without checks on their authority, they become petty tyrannies. With proper limitations and respect for homeowner rights, they can actually improve communities. The law I'd helped inspire became a model for other states. Colorado adopted similar protections. Nevada strengthened its HOA statutes. Texas, which had some of the most aggressive HOAs in the country, passed comprehensive reforms. The movement was spreading, and it all traced back to that day. Patricia Hendricks demanded entry to my home. Sometimes I wondered what would have happened if I'd backed down. If I'd let her conduct her bogus inspection, accepted the harassment, paid the fines. I'd probably be living somewhere else by now, driven out of my own home by a bully with a little bit of power and no understanding of constitutional limits. Instead, I was sitting on my porch in my home, enjoying a September evening in Arizona. My home, my castle, protected by the Fourth Amendment and my willingness to defend it. The next morning, I woke to find an email from the Arizona Bar Association. They were giving me an award for public service, recognizing my work on HOA reform and my contribution to protecting homeowner rights. The ceremony would be in November. I accepted, though awards weren't why I'd fought Patricia. I'd fought because it was the right thing to do, because principles matter. Because the Constitution isn't just a document for criminals and terrorists. It protects all of us, in our homes and our daily lives. November came, and I attended the ceremony in a rented tux. The ballroom was full of lawyers, judges, and legal professionals. When they called my name, I walked to the stage and accepted the plaque. Harrison Dalton has demonstrated extraordinary commitment to constitutional principles and homeowner rights, the presenter said. His successful defense against HOA overreach not only protected his own property, but led to legislative reforms that benefit all Arizonans. He exemplifies the best of our profession. The applause was nice. But as I stood there holding the plaque, I thought about Patricia's face when Judge Rivera ruled against her. The shock and anger. The realization that her authority had limits. That was the real reward. After the ceremony, several judges and attorneys approached me to discuss HOA cases. One judge pulled me aside. "Harrison, I'm glad you fought that battle. I've seen too many HOA cases where homeowners just rolled over because they didn't know their rights. You changed that." "I hope so," I said. "Everyone deserves to feel safe in their own home." "They do. And thanks to you, they're a little safer now." I drove home that night thinking about how strange life could be. A year ago, I was just a constitutional lawyer living in a Phoenix suburb. Now, I was the face of HOA reform in Arizona, all because Patricia Hendricks couldn't leave well enough alone. The holidays came and went. Saguaro Ridge had a neighborhood Christmas party that I actually enjoyed. People were friendly and relaxed. The HOA board announced several successful initiatives, including negotiating lower insurance rates and installing new playground equipment. In January, exactly 1 year after Patricia's visit, I received a call from a producer at a local news station. They wanted to do a story on HOA reform and the anniversary of my case. "I'd rather not," I said. "The case is over. The reforms are in place. I'd like to just be a regular homeowner now." "I understand," the producer said, "but your story could help other people dealing with similar situations." She had a point. I agreed to a brief interview. The segment aired a week later. They showed my house, interviewed me about the case, and talked to Jennifer about the reforms. They even got a comment from Daniel Brennan, who admitted his former clients had made serious mistakes. The best part was at the end. The reporter stood in front of the Saguaro Ridge sign and said, "Thanks to one homeowner's willingness to stand up for his rights, HOAs across Arizona are now more accountable and more respectful of constitutional limits." It's a reminder that the law isn't just for courtrooms. It's for our homes and our communities. The segment went viral online. I got messages from people across the country sharing their own HOA horror stories and thanking me for fighting back. Some were heartbreaking. People driven from their homes by fines they couldn't afford. Elderly residents harassed over trivial violations. Families torn apart by HOA foreclosures. I couldn't help everyone, but I tried to point people toward resources and attorneys who could help. I also started writing articles about HOA law and homeowner rights, trying to educate people about their options when facing overreach. The work was rewarding, but also sobering. Patricia wasn't unique. There were thousands of HOA board members across the country who saw themselves as rulers rather than servants, who confused authority with power, who forgot that their neighbors weren't subjects to be controlled but fellow homeowners deserving of respect and dignity. But there were also good HOA board members, people like Jennifer and Robert and Donald, who genuinely wanted to make their communities better, who understood that rules should be reasonable and enforcement should be fair, who respected the rights of homeowners even when it was inconvenient. The difference between good HOAs and bad ones often came down to leadership, and leadership came down to character. Did you respect other people's rights? Did you treat authority as a responsibility or a weapon? Did you serve the community or yourself? Patricia had failed that test. She'd chosen power over principle, control over cooperation, and it had cost her everything. Her position on the board, her reputation, her place in the community, all because she couldn't accept that a homeowner had the right to say no. I sometimes wondered if she'd learned anything from the experience. The apology letter suggested maybe she had, at least a little. But people like Patricia rarely changed fundamentally. They just found new places to exercise their need for control. As for me, I'd learned that being a constitutional lawyer wasn't just a job. It was an identity. When your rights are threatened, you can't just rely on someone else to defend them. You have to be willing to stand up yourself, to fight back, to insist on the protections the Constitution guarantees. I'd also learned that the law worked when you used it correctly. I'd filed the right motions, cited the right cases, made the right arguments, and the system had responded. Judge Rivera had seen through Patricia's pretextual claims. The legislature had passed reforms. The community had changed its leadership. Justice in this case had prevailed. That didn't always happen. I'd lost cases before. I'd seen injustice go unremedied. But this time, at least, the good guys won. Spring arrived, bringing warm weather and blooming cactus flowers. My desert landscaping looked spectacular, the native plants thriving in ways that non-native species never could. I sat on my porch one evening, beer in hand, watching the neighborhood kids play in the street. This was what Patricia had threatened. This peace. This sense of home. She'd wanted to violate my space, impose her will, make me feel unsafe in my own house. But I'd stopped her. And in doing so, I'd protected not just myself, but everyone who'd come after me. The doorbell rang. I opened it to find a young couple I didn't recognize. "Mr. Dalton?" the woman asked. "I'm Emily, and this is my husband Jason. We just moved in down the street. Jennifer told us about your case with the old HOA board." "Welcome to the neighborhood," I said. "We wanted to say thank you," Jason said. "We almost didn't buy here because of the HOA's reputation. But when we heard about the reforms and new leadership, we felt comfortable moving in. Our realtor told us the whole story." "I'm glad it worked out," I said. "Jennifer also said you're a lawyer who specializes in HOA issues," Emily continued. "We're attorneys too. We do employment law. But we were thinking it might be good to have your contact information, just in case we ever need help with HOA stuff." I handed them my card. "Hopefully you won't need it. The new board is reasonable. But yes, if any issues come up, let me know. We chatted for a while about the neighborhood and Phoenix generally. They were nice people, young professionals looking for a place to put down roots. The kind of homeowners every community should want. After they left, I realized that this was Patricia's real legacy. Not the harassment and overreach, but the reaction to it, the reforms, the new leadership, the sense among homeowners that they had rights and could defend them. She'd inadvertently made Saguaro Ridge a better place by being such a terrible HOA president that the community had rallied to fix the problems. There was a lesson in that. Sometimes the worst people catalyze the best changes. Sometimes you need a Patricia Hendricks to show everyone what not to do. Sometimes tyranny has to be experienced before people appreciate freedom. I just wished it hadn't been my doorstep where that particular lesson played out. But it had, and I dealt with it. I'd recorded everything, as the news story had said. I'd used my legal knowledge to fight back. I'd stood on principle and won. And now I could sit on my porch, drink my beer, and enjoy my home without looking over my shoulder. The sun set, painting the sky in shades of orange and purple. Somewhere in Tucson, Patricia was probably watching the same sunset. I wondered if she ever thought about what had happened, if she regretted her choices, if she understood why she'd lost. Probably not. People like that rarely did. But it didn't matter. The case was closed. The reforms were in place. Life in Saguaro Ridge had moved on, and I was home.